You think, if I understand the position correctly, that Garmin does not cover the failure to take reasonable precautions to protect property, right?
Yes, Mr. Chief Justice.
Well, it seems to me that if it doesn't cover that, it surely cannot cover the intentional destruction of property. Does that seem reasonable?
That certainly seems reasonable, but we have additional qualifiers on this reasonable precaution standard that illustrate the difference between it and Mr. Francisco's standard. The first is that our standard applies.
Well, just to make sure we're walking down the same road here, what I'm looking for is reasons that intentional destruction of property would not follow a fortiori from failure to take reasonable precautions to protect property.
It depends on what destruction means, Mr. Chief Justice. If by destruction you mean the type of imminent harm that we're talking about, then yes, we agree that intentional destruction is a subset of our standard. But it's not clear that Mr. Francisco's standard is limited to that type of imminent harm. For example, let us say that grocery workers walk out of the grocery store and the food in the store spoils. I'm not certain whether Mr. Francisco would describe that as destruction of property or not.
But I mean, the same ambiguity, it seems to me, would accompany reasonable caution to preserve property. I mean, if you're striking against a grocer, maybe sure, it's sort of inevitable that, the milk is going to go sour if you're not there. But in other words, that ambiguity doesn't seem to me to justify the distinction between those two categories.
And it is precisely to deal with that problem that the board has added a few additional words beyond just reasonable precautions. It's reasonable precautions to protect property from foreseeable imminent harm caused by the sudden cessation of work. That, we think, has allowed the board to say that there is a meaningful distinction between the spoilage of products that happens in the ordinary course and the type of harm that is alleged in this case.
Well, but what you're saying is Garmin may or may not cover the fact that the milk is going to go sour or whatever it is, but we know that it doesn't, I always get these mixed up, but it does cover somebody who deliberately opens all the containers of milk and pours them down the drain. It just seems to me that intentional destruction of property is a much more serious concern than failure to take reasonable precautions, even if you want to add imminent and all that other stuff. But as I understand your position, you want to compel Mr. Francisco's client to squeeze its intentional destruction claim into failure to take reasonable precautions.
I think we must distinguish, Mr. Chief Justice, between affirmative acts like pouring the milk down the drain and merely stopping work. Now, we accept there are some circumstances in which the union chooses an inopportune moment to stop work that is unreasonable under the circumstances. And that's what our reasonable precautions test is meant to address. But if you're concerned about pouring milk down the drain or affirmative acts like that, we have no objection to the notion that that is unprotected, entirely apart from the reasonable precautions test that we have been advancing.